The last bill on the agenda is House File 3380. Representative Hudson, since this is still your bill, you can remain at the testifier's table. Your bill may have a cost to the general fund, so we will be laying over the bill today. There are amendments to your bill, but we will allow Representative Hudson to present the bill first. Representative Hudson, please explain your bill.
Thank you, Mr. Chair. Thank you, Chair Moeller and members. House File 3380 addresses a very specific and very dangerous group of offenders, people who have repeatedly committed violent felonies with firearms. Minnesota law already recognizes repeat violent offenders as a serious threat, but under the current statute, enhanced sentences for those offenders are optional, and too often they are not applied. And the result is predictable. Chronic violent offenders cycle through the system, receive downward departures, and return to our communities. In fact, sentencing data shows that in Hennepin and Ramsey counties, roughly 3/4 of felony offenders receive some form of downward departure from recommended sentences. House File 3380 addresses that failure directly. This bill says that when someone commits 3 or more violent felonies involving firearms, the court must impose an aggravated sentence up to the statutory maximum, and that offender must serve the full term. No early release, no probation, no cycling back into the community after repeated armed violence. Members, you may recall I presented a similar bill last year which had a broader focus on any violent felony. While we weren't able to come to agreement on that proposal, I would certainly hope that this narrower approach, focusing exclusively on those who have habitually committed violent felonies with a firearm, would be met with bipartisan approval. By the time someone commits their 3rd violent felony with a firearm, they have demonstrated beyond any doubt that they pose an ongoing danger to public safety. By contrast, a proposed delete all amendment shifts the focus from serial criminal activity with the firearm to the lawful possession of firearms by law-abiding citizens. The contrast in approach to that issue could not be more clear, but I remain hopeful that protecting the innocent from those proven guilty beyond a reasonable doubt on 3 separate occasions will be a higher priority for this committee than disarming innocent and vulnerable Minnesotans. Thank you for your support.
Thank you. And we have testifier Dave Zimmer. Mr. Zimmer, please go to the table, state your name for the record, and begin.
Chair Novotny and committee members, my name is David Zimmer. I served 33 years in local law enforcement and have served the past 4 years as the Public Safety Policy Fellow with Center of the American Experiment. In this capacity, I appear today in support of House File 3380, which would improve public safety by ensuring a more consequential criminal justice system. In the past 3 years, I've attended many of the hearings in this committee. There has always been appropriate debate over the best way to address penalties for nonviolent property and drug crimes. And thankfully, this committee has historically found agreement on issues involving crimes of violence. I believe this bill offers you yet another opportunity to find agreement. Agreement that would tighten loopholes currently exploited by violent offenders. Agreement that would reestablish appropriate consequences for committing multiple crimes of violence. An agreement that would help deliver justice to victims of violent crime in our state, a group that is far too often forgotten in our offender-centric system. The strength of this bill, in my assessment, is that it focuses exclusively on violent offenders, not those who have made a single one-time mistake, but on repeated violent offenders and those who use firearms to carry out their violence. This is not a controversial policy. The bill addresses issues in 5 straightforward sections. First, it strives to codify in statute what the DOC is currently doing by policy. That is, making many crimes of violence ineligible for early release as part of the Minnesota Rehabilitation and Reinvestment Act, MRRA. The DOC appropriately created a list of 61 violent crimes that it has deemed ineligible for their early release program. However, that policy is quietly sunsetting next year, making it important for this body to codify into statute. Sections 2 through 5 of the bill seek to strengthen statute 609.1095, which deals with increased sentences for certain dangerous and repeat felony offenders. I'll note that 609.1095 was created in 1998, following a particularly violent period in our state, not unlike the period we have recently endured in the 2020s. Just as the public had seen enough of repeat violent offenders cycling through an ineffective system in the mid-1990s, the public today is again weary of that very same revolving door of justice. This file would help slow that revolving door, ensuring those committing repeated crimes of violence are incapacitated, protecting the public while providing correctional authorities the time it takes to make earnest efforts towards rehabilitation. Minnesota continues to be among the states with the lowest imprisonment rates in the nation. We currently imprison 143 per 100,000 people, a rate less than half the national average. Given the revolving door of justice that many victims of violent crime have witnessed in Minnesota, that is a figure that must change. House File 3380 strives to make that change by holding repeat violent offenders accountable, and I urge you to vote in favor of the bill. Thank you.
Are any of the members of the public that wish to testify? I'll get his attention. Mr. Rice, are you here to testify at all? All right. Just want to see if you're paying attention.
He's going to run out.
Members, questions for Representative Hudson and his testifiers? Mr. Pinto, Representative Pinto.
Thank you, Mr. Chair. Thanks, Representative Hudson, for the discussion about this. So I guess maybe one just general question. Like, are you? I know the general rhetoric about how cases are handled, but I'm wondering, like, can you point to a specific incident, a specific sentencing, a specific something that you can say, you know, and really, since you want to require this of judges, even sort of a number of cases you can point to. Like, is there something you can point to specifically?
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Pinto. Perhaps Mr. Zimmer has access to data as he's taken quite a look at that. My understanding is that in the aggregate, we're talking about a significant percentage of cases. I believe, what was it that I had in my testimony here? 2/3 in Hennepin-Ramsey County. 3/4 of violent felony offenders receive some form of downward departure from recommended sentences. If that's not the case, that would be welcome news, but that's my understanding.
Representative Pinto.
Thank you, Mr. Chair. Well, and interestingly, with that statistic, even if that's true, you're actually saying that they should be not getting a departure. And of course, if there is a departure, that's the details are written up. So actually, every one of those sentences, there has to be, the reason has to be provided publicly. So actually, there's plenty of opportunity for you and anybody to challenge any one of those sentences. Your bill actually is saying not that people should be avoiding getting a downward departure, that actually be required to get an upward departure. Significant separation of powers concerns there, of course, regarding directing judges in that way. But I guess I just sort of, before we get into the concerns about the language, just sort of conceptually, every one of those cases, you should be able to bring up and show, well, there's this departure that the reason was given seemed to be not adequate. It's all public. And so it's just notable to me that we don't have that. This is a pretty complicated area of law, and there's a lot of things combined here in the bill. I guess one thing that jumped out at me, I'm looking on page 3, I guess it is, the middle of the page, that requiring a court to look back at the prior convictions to see whether the offender or an accomplice had in possession used a firearm. This could go back many decades, right? I mean, depending on how old somebody is, I don't know, this might be 40, 50 years. How would that work? I'm just not aware of that in any other laws. We'd be requiring a court to do that kind of analysis.
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Pinto. I fail to see the complication. It's pretty simple. Did they have a prior felony violent conviction proven beyond a reasonable doubt where a firearm was involved? If so, and this is their third time doing specifically that, I don't care how many years it's been, they've probably opted out of polite society. And to your broader point regarding departures, I think it's entirely appropriate for the people of Minnesota to express through statute that past a certain point, we are putting our foot down. We don't care what your reasons are. We don't care what your story is. We don't care what excuses you have for why 3 times you have been convicted beyond a reasonable doubt, proven to have engaged in a crime with a firearm. Past that point, I don't want to hear the detailed explanation in a departure statement from a judge as to why we shouldn't throw the book at them.
Representative Pinto.
Thank you, Mr. Chair. But Representative Hudson, I guess the concern is, you're putting your foot down on something that may not even exist. I mean, you're not like, this is why we actually want to look at specific incidents and specific cases and understand them. You're saying, somebody who has 3 violent convictions should be sent to prison. And in fact, the law requires that they go to prison. What you're requiring is that they go to prison for a greater length of time. Interestingly, the way this is written, it would be just 1 extra day, correct? I mean, a judge could comply with this just by giving somebody 1 extra day in their sentence, is how I read this. Is that correct?
Representative Hudson. I had a hard time understanding or hearing the question, but
Thank you, Mr. Chair. Representative Pinto, I'm not sure I understand the premise of your question. The maximum, as I recall, the statute says, or the bill says, you're going to impose the maximum statutory penalty. I don't know how that would translate to 1 extra day, and I suppose it would depend very much on whatever other type of sentence that's a downward departure they were considering.
Representative
Thank you, Mr. Chair. Well, no, Representative Hudson, like if you look at that, the area I was pointing to before, which I guess is page, and I'm sorry, it was page 2 actually, not page 3. The stapling confused me. So line 2.14, so the judge for this particular section must impose an aggravated durational departure, which just means that if the number of months is whatever number of months is the top of the box, the judge has to exceed that, up to the statutory maximum. So the maximum the judge could do it is up to the statutory maximum. As long as the judge imposes an aggravated durational departure, so 1 day, a week, a month, anything, they can't exceed the statutory maximum. But the way this is written is that the judge has to impose it, does have to impose an aggravated durational departure. That assumes the judge, that we get through separation of powers problems. But if we do, then the judge can do it just by doing an extra day or week. I guess maybe it's your intent that the judge actually would have to do it up to the statutory, that they would have to actually reach the statutory max. They can't sort of stop midway. Is that right? Or what are you intending?
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Pinto. I believe you're making the argument for me here that there's still discretion that the judge has to decide how long the person is going to be sentenced. What we're saying is we're sick and tired of the downward departures for people who have 3 violent criminal felony convictions involving firearms proven beyond a reasonable doubt. Past that point, I'm happy to let a judge have some flexibility in how they're going to sentence, but it ain't going to go down. It can go up.
Representative Pinto,
Thank you,
just like
Mr.
to point out in line 3.31, or 3.30 to 3.31, person convicted and sentenced as required by this section is not eligible for probation, parole, discharge, or work release until that person has served a full term.
Yes, but thank you, Mr. Chair. Yeah, so pursuant to that sentence, it means that if the judge did give that extra day, the person would have to serve all the way to that extra day. It wouldn't mean that it served the statutory maximum. Those are sort of different points. And Representative Hudson, I think, again, we want to be really careful with identifying what problem we're trying to solve and what solution are we bringing forward. Because the problem of you having concerns about downward durational departures, which we don't have one example of actually, but perhaps at some point we will, that's not the problem being solved here. The problem being solved here is that you think that people not receiving downward departures is bad. You want them to get upward departures. So these are different things, and we sort of had skipped past this, but I did want to just get back to the point earlier about having to look back at prior convictions. It is not a small matter to try to figure out from a conviction from 20 years earlier if an accomplice, somebody else, not the offender themselves, was in possession of a gun. That's probably going to require a lot of digging. So there's a lot of concerns with how this is structured, but I guess fundamentally, I'm just still trying to figure out, I know the general rhetorical problem you're trying to solve, or sort of the message it's trying to send, perhaps. But the question is, what actual problem are we trying to solve? A reminder that anybody convicted, anybody for whom this applies, is already receiving a significantly longer guideline sentence because, in fact, they've got a violent felony involving a gun. I understand you're concerned that then there are these downward departures, which you don't like. Boy, let's have some examples of that because it's all available and it's all public. And just sort of having a sense of how things are working is probably not a great way to legislate. Thank you, Mr. Chair.
Thank you. Representative Engen.
Thank you, Mr. Chair, and thank you, Representative Hudson. And while I appreciate the legalese and the academia of the lawyers in the room, we're simply trying to get to a point in which Minnesota recognizes that committing 3 violent felony conviction actions with a firearm is held to a standard that cannot go down. And that seems to be a reoccurring theme that we don't want to address. There are instances of that occurring. A 2014 study showed that we have downward departures from mandatory minimums in 56% of all gun cases in Hennepin County and 53% statewide. We don't want that to happen anymore. And I think that this language strikes at exactly that. So thank you.
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representatives Engen and Pinto. So I want to address this notion of having a general sense as opposed to coming in here with some sort of dissertation with a bunch of citations, citing every time there's been a downward departure involving somebody who's had 3 different violent felony convictions. The fact of the matter is the general sense that I have is based in observable principle. If in fact this isn't happening, then there's no argument against it. Also, we know it's happening. I don't know how. I mean, the idea that we have access to this public information, so I didn't bring in a Rolodex of file cards with downward departure notes on it. But the minute we leave here, that research can and will be done. And then you're going to have to answer to why you were claiming this isn't a problem. And I'll take that bet any day of the week. We have a problem with activist judges giving reduced sentences based on irrelevant criteria like their personal story and what they look like and their skin color and where they grew up, and not take into account the conduct, which we discussed during a previous bill, and how harmful that is and the ongoing public safety threat that it poses to people in Minnesota.
Co-Chair Moeller.
Thank you, Mr. Chair. And I just wanted to be clear because you've thrown the statistic around about 3/4. Can you tell us precisely what you were looking at when you said 3/4 of, I just missed it, like the violent felony? What statistic are you looking at there?
Representative Hudson.
Thank you, Mr. Chair. Thank you, Chair Moeller. Where I got that from in my statement is from research that I don't have in front of me at the moment, but I believe it's on my desk or at my seat. So the point is, I can give you the answer later.
You might be phoning a friend right here unintentionally.
We have a report from the Sentencing Guideline Commission. It was with the graph referring to 2nd District, Ramsey County, and 4th District, Hennepin County. I don't see it. In 2024, a specific judge, who I shall not name, had the lowest mitigated departure rate of 31%. The lowest mitigated departure rate was 31%.
All right, and I guess I don't know enough about what cases we're talking about. Are you just talking about all violent felonies? And the reason I ask, I guess, more importantly, is I took a look because I know in past years I've often heard citations to the guidelines about the cases allegedly involving firearms and then those where the mandatory minimums were given. And so the sentencing guidelines list county by county what the percentage is. And the cases where the most mandatory minimums were ignored when there were, I looked at counties with greater than 12 cases allegedly involving a firearm, were Mille Lacs at 0%, Pine County at 1%, Nobles at 6%, Benton and Crow Wing at 8%. When I looked at the cases allegedly involving firearms in the metro, Anoka was at 36%, Dakota 29%, Hennepin 30%, Ramsey 42%, and Washington 28%. And so, there's always this idea that like the metro is doing something nefarious with these cases. And when you dig into the details, you'll see that in greater Minnesota, the mandatory minimum is given less frequently than in some of these counties than it is in the metro area. I also just wanted to comment in the sake of time, because I know there's a couple amendments too. Victims were invoked, and I don't know that any victim advocacy groups were consulted here. Certainly don't know that any victim advocacy groups that work with gun violence victims or survivors were consulted with this. I'll note that sometimes departures are given because victims in cases just don't want to cooperate. And cooperate maybe is not the right word, or don't want to testify. And so for them, agreeing to a plea deal where there's a lesser sentence might be something that they actually desire. And so I just wanted to make sure that to mention that as well. And then to Representative Pinto's point about whether or not it's hard to prove whether an accomplice at the time of an offense years and years, decades ago, had in possession a firearm is very difficult. Even now, if there's a firearm in a car with 4 people, it's very hard to even prove who is the person in possession of that firearm, let alone decades ago. And of course, to satisfy Blakely, I'm sorry you look so bored with this, but in order to satisfy Blakely, the Supreme Court case, a prosecutor has to prove beyond a reasonable doubt those factors. So it is very difficult to prove and does require proof beyond a reasonable doubt. With that, I'll stop.
A little out of order, but it sounds like Representative Pinto, did you have a final comment? No?
No.
Okay, misinterpreted. Okay. Walt, Representative Hudson, respond.
Thank you, Mr. Chair, and thank you, Chair Moeller. You misinterpret. I'm not by no means bored. I'm frustrated and befuddled because this seems like a pretty simple concept, and I don't understand why it continues to be complicated by questions of process. If there's any ambiguity as to whether or not a firearm was involved in a violent felony conviction, then that's probably not going to count towards this total, and that's fine. If anything, you're making the case stronger for this, because in a case where it's unambiguous that a firearm was involved in a violent felony conviction and it's happened 3 times, there is no reason that person should have access to early release, to parole, to reduced sentencing. They certainly, at the very limit, if there's going to be any departures, it should go up. And if it is in fact just 1 day, well, that's one more day the people of Minnesota will be safe.
Thank you. This is a long-standing case. It had a bill that I originally carried. The concept of third strike, and this is in statute. It's not something that we invented. It's been there a long time. At some point, someone probably sat in this room and passed this bill that they thought it would be a good idea, that someone on that third time at the plate getting the chance needs to serve their time. Originally, the bill had the language of shall instead of may, that's what we wanted to change, shall to may, which means at some point, members just like us sat in this room and wanted to hold people accountable and make sure that after the third time they've demonstrated their willingness to use violence, that they not be given less of a sentence to protect the victims out there. There is an amendment, and I have reviewed the amendment, DE2, and I find that amendment is out of order. And
Mr. Chair,
House
Mr. Chair,
File 3380 is laid over.
Mr. Chair, Mr. Chair.
Madam Co-Chair.
We have not traditionally called amendments out of order in this committee. That is something that I've seen on the floor, but I have, in all my years in the legislature, have not once seen that in committee.
Well, Madam Co-Chair, we'll be laying this over, and if you want to pull it up again, you can do that.
Mr. Chair, can you give the grounds, Mr. Chair, for ruling it out of order? What was your grounds?
This meeting is adjourned.
No, what is,
Wow.
Mr. Chair?